We are here, the I Just Want This Done Divorce podcast. Let me see if I have the air horn sound effect. Here we go. Yeah, well, hey, what's happening, everybody?
What's up?
We're here for another episode 66 of the I Just Want This Done Divorce podcast, coming at you live and worldwide on many streaming platforms and YouTube. And for those of you on X out there, we're there too. So thanks for watching. We appreciate it. We got a fully loaded show today. This is our special late summer edition. This should broadcast next week. The live stream is typically Thursday. Following week, Friday, usually it gets published. So, but you get to see it raw and uncut live. So, watch as we do our death-defying act here, live and unedited.
Okay. The director's cut.
So we are this show is sponsored by STG Divorce Law. We help smart, successful people get divorced in Chicagoland. And we've been doing it since 1994 with awesome lawyers and a great team. And we love helping people solve their divorce challenges. Check us out at stglawfirm.com. Rahul Ayers, say hi to the folks out there. Oh, he is frozen. What happened? We have a connection problem. Come in.
Out there. That is, and I'm back.
And he's back. All right.
And
well, the good news is the audio will be correct on the full version because it synchronizes. All right.
Exactly.
You're back, of course, when we need it to work, right?
And I'm back. Hi, folks. I said hi. I could hear everything. I just probably was frozen. So we'll try to make sure the audio is fixed.
It's okay. It'll be the way that Riverside works. It should be fine. Okay. So we've got a fully loaded show today for you guys. We're going to talk about the big hedge fund mogul divorce story that you've probably heard some things about or seen some social posts. We're going to do a little bit more of a dive into this case to explain what the heck is going on here, because there's some super juicy stuff happening in this case that is very interesting from a divorce lawyer standpoint, some kind of do's and don'ts in this thing. I'm going to lower my chair to get by my microphone. Sorry. See, that's amazing. Okay. And we're going to get into that 6.2 billion demand by the wife in the divorce. She wants something like 35% of this guy's assets. And we're going to talk about that situation and what, why he's offering a fraction of that in settlement. Then a Cleveland divorce battle, folks. Yes. Cleveland, city by the lake. Those of you who've been at Case Western Reserve University. No hate.
Probably the most exciting thing that's happened in Cleveland.
Yeah, we've got some exciting news about two local celebrities getting divorced. They're news anchors in Cleveland. And why are we talking about it? Because it's got some interesting stuff in it about cooperating with court orders and evidence and things of that nature that I think are interesting. And then Quentin Aaron, who's a star of Blindside, it's a show, and wife haven't spoken since he found out something surprising about her after his 4-day coma. And so that's an interesting little story. We've got a question from our audience, our private Facebook group, the Illinois Divorce Support Network, about parenting coordinators. We're going to talk about who they are, what they do, kind of like tips and tricks about working with those folks and answering our question from the audience and discussing the applicable rule in Illinois. And there are similar people in other states that take this role on. So that's what we've got here. So Rahul, let's get into this big divorce with this billionaire. What's the story on this?
Yeah, absolutely. So like you said earlier, we're fairly certain you may have heard of this. It's been making the waves on social media and all the news platforms. And so there's plenty of articles out there. We're using an article from the New York Post and then also through Yahoo Finance. So this is a divorce between what they call who they call a billionaire hedge fund mogul named John Overdeck and his wife Laura Overdeck, and John is the I guess, I don't know if he's a majority owner, but he owns approximately 35 he owns a large percentage, if not
the majority interest,
percentage of Two Sigma Investments firm, and he's based out of New Jersey. And so
this guy looks like a guy who would own this investment.
Right.
We will. So
they were married without a prenup. Yeah.
Yeah, no prenup. I'd never heard of this guy ever.
No.
He's a billionaire.
Yep, absolutely. So he never heard of him either, and he's making all the waves now. So she is, I guess, they're in divorce. It sounds to me like I can't really tell from the article if the trial has commenced or if just they're still going through the pre-trial motions, as they say. She wants $6.2 billion of his fortune. He's
Okay.
offered her 633 million. And they called this the largest divorce battle in New Jersey history. So she's looking the 6.2 billion is like roughly a 35% piece of his $80 billion firm.
Okay.
And you know, that's what it is. Now he argues, so he argues that, well, hey, I set up this firm about 2 years before we got married. So I don't know you that much. So we're now obviously in the thick of things, and they're both talking about how, and you know what? It says they have an opening statement here, and so it looks like the trial has commenced. So this is where people will start doing their opening, their
Yep.
direct exam, cross exam, calling witnesses, putting in evidence, and then the other side will have their case in chief where they'll give their narrative, their evidence, and then the court will have to call balls and strikes on what they think is happening here.
So
So,
there's a couple of interesting. So we want to kind of explain to the audience a little bit here.
yes,
This guy, he's only, how old are these folks? They can't be even, they look like they're in 40s. You don't normally get the ages, but they don't look like they're over 40 something. So this is like his first marriage. So not unusual that the guy doesn't have a prenup. A lot of people in their first marriages don't.
right.
And he started this fund. He started this company before they got married. So in our state, that means it's a non-marital asset. However, there's
There's a but.
tremendous growth in this asset after the marriage, and she really probably contributed to that. And in our state, the concept is the married people are equal partners to the, if you think of the marriage as a like a pie, generally speaking, in Illinois, we say they're 50-50 owners of the marriage, of the marital estate, if you think of it like a company. And this guy started the business before the marriage, technically non-marital property, but 99% of the gain in this thing was after they were married. So in Illinois, she'd have some argument to say his personal efforts, which is the fruits of personal effort, become our marital property. That would normally be the income
Like the
earned
effort he put in, like the labor he did
to grow it.
to grow it.
And so if this guy has taken, and they're going to have to pull all this apart, and expert witnesses dig through all the evidence, but let's say this guy plowed every dollar he made in this business back into it, and it kept growing and growing and growing. She has a decent argument to make that if not half, that I should get some percentage of this thing because a lot of it is marital. And that's how
Yeah.
much is the big battle. That's like, how much should be marital? Well, that's going to be up to a judge to decide after a judge hears two different experts battle over how much was this guy's personal effort? What's the value of the business? There's a bunch of open questions.
Did the
So,
marriage benefit from did he compensate the marriage
yes,
adequately, right?
right. That's another big question. And we're using our state law, but most states are pretty
Correct.
similar. So
Mhm.
the idea is if he paid the marriage, so if he took compensation that was fair based on what the company was earning and what his job was, then she really can't say she was shorted. The problem is some of these guys will take a very small salary and plow the dollars right back in the business.
Mhm.
And then the marriage kind of gets cheated out of the money and it sits in the company. And the spouse would, in that situation, the spouse typically says, don't worry, honey, we're making it, this company's worth a ton. We're all good. And the company's paying all their expenses and they're living high in the hogs. So the spouse doesn't care. Because if
We're doing it to
I'm
avoid
married,
tax liability, things like that, right?
yeah, like we're good. We're living high in the hog anyway. We don't need all this. And the company
Mhm.
pays for the condo and the cars and the jet and all that stuff. So,
Right. What do you
you
care? You
know,
have the corporate card. Spend what you want.
yeah. So there's no need for me to worry about pulling
Mhm.
out a big salary. And a salary, of course, you pay really high income tax. So relative to investment, capital gains. So a lot of times you see these things where the marriage is undercompensated, and then the value of the company grows and grows and grows. And she's saying, well, where's my portion of this? And his argument is, well, I built the company before you were around. It's only a year though. Her argument is most of the years we were married. So this is a sticky wicket. It's going to have to go through a big trial with, if it doesn't settle, with experts testifying and a ton of evidence, because this is a big company. So when you look at these two demands, or the demand and the offer, right, Rahul, they kind of make
Yep.
sense if you're looking at it from each person's perspective.
Oh, absolutely. Everyone, this is a chess piece, a chessboard, and you got the top two chess players in the world, and one makes their first move, the other makes their second move, and so it's like your classic negotiation. It's like they want 35%. If you look at Jeff Bezos's divorce, kind of similar. I mean, albeit he was worth a lot more money.
Right.
She ended up getting the largest divorce settlement in history, like we talked about a couple of episodes ago. And so again, that wasn't a 50% stake though. It wasn't.
Right.
It was less. It was probably in the 30s or something. So
And
they kind of,
interestingly,
yeah,
she's not asking for half, right? I mean,
right.
it's pretty.
Mhm.
So her lawyers are kind of saying, look, we could ask for half. We're not. We acknowledge there's some value in the
Mhm.
guy building this. And so they're doing the playbook that I would be following, which is be reasonable on your first offer. Don't, they're not getting 50-50. They know that
Right.
coming out of the
Exactly.
gate, because the company, is the biggest asset by a long shot. And it was before the marriage. They have that problem. They know it. They're acknowledging it with this demand. I think they're clearly acknowledging and staking out what appears to be, at least at the outset, a pretty reasonable, especially starting move. And then the other guys are taking the
Right.
point of view like, hey, we won't really owe you anything. Here's this
But here's-
633 million.
Yeah.
That's probably the money the guy is, he's probably pulled out
Right.
what, a couple $1 billion in their family assets, or maybe $1 billion.
Absolutely.
And he's saying, I'll give you more than half,
Right.
Now, here's an interesting thing though. Rahul, tell the audience like what happens when the non-marital estate is a monster compared to the marital estate.
Right. So in Illinois, and this is something I was going to mention as well, in Illinois, if one party has a substantial non-marital estate, and since it's in a quote unquote equitable division state, the court says, you know what? It's not equitable for this to be a 50-50 split if one person also has this much additional non-marital assets. So we're going to make it a 60-40 split or a 65-35. I mean, it'll go as high as the judge deems it to be what'll make it equitable.
Yeah.
So
In extreme
right.
cases, it might be all of it.
It might be all of it. Right. Exactly. So you get all the marital estate because this guy's worth, $8 billion and has a humongous company that's worth
Yep.
hundreds of bills or whatever it's worth. So yeah, it's definitely possible. I think it sounds like both these lawyers, obviously, needless to say, know what they're doing and are strategically making moves, but it remains to be seen. One other thing this article points out is that her attorneys are arguing that this guy had a concept or a notion of a company, but the company wasn't really doing anything or worth anything at the time of the marriage. So it's like saying, you start up an LLC, you're not really doing anything with it. There's no accounts, there's no business there. So does that mean just because I opened this entity, does that make everything non-marital? They're basically saying, look, everything you did was during the marriage.
Yeah.
So you're lucky we're not asking for more than what we're asking for. So
yeah, Overdeck's, John's lawyers, the husband, say his wife not entitled because firm founded 2 years before their marriage in 2002, already established in the hedge fund world. A quote was, apparently this trial has been ongoing, because this is a quote from opening statements. Interesting.
Right.
The attorney Wolf for this guy said the company did substantial work. I'm paraphrasing, managed hundreds of millions of dollars before the party's marriage. Then the other attorney said, as you pointed out, the company was a concept or notion of a company. So it'll be interesting. There's no ruling on this yet. But, and it says John Overdeck and his fellow co-founder each own roughly half of the firm. There's been a power struggle. Yeah. So then another thing, her lawyers are accusing him, Mr. Overdeck, of planning for divorce way in advance. They say planning for
Hmm.
20 years, which sounds extreme.
From the day he
This
got
guy's been
married.
planning for 20 years. My first advice to him, if he came to see me 20 years ago, is file for divorce now, because your asset
Or
pool
post.
keeps growing. You know,
Yeah.
don't
I
plan,
would
get
certainly
it
not
done.
wait 20 years. Yeah.
And my advice to you guys out there who are making a ton of money, sooner is always better than later. I'll tell you a brief story. I had a potential client call me on a consultation several years ago. He owned a company making a certain kind of manufactured product that's made to high tolerances, and it's a precision product in a growth industry. And his company was making a lot of money, and he was telling me that next year it was going to be like double, and he anticipated the growth to continue. And he's like, should I get divorced? I said, well, I'm not the guy to tell you to get divorced or not to get divorced. But if you're going to get divorced, the time is yesterday, because
Yes.
she's going to keep getting half of a bigger and bigger. In their case, the company was formed during the marriage. So she's going to get half of a continually growing number. Every year you wait, she's getting free money.
Oh yeah.
So I said, hurry up and get started. If you're going to get divorced, the time is now. And he waited. He called me about a year or two later and said, I'm still thinking about it. And now he's making way more money. And what should I do? And he kept having this I don't know if it's called the sunk cost fallacy or something, but he kept saying, I don't want to get divorced because I'm losing so much money when I get divorced. And my point was, clearly you want to get divorced, and every year you wait fretting about it. First of all, she might divorce you. It might not be in your control at some point, and you're giving up half. So my advice to him was, you got to get going on this.
If you
And
don't file for divorce, if you want to get divorced and you haven't filed after you made your first $100 million, maybe do it when you make your 500. Hell, do it when you make $1 billion. Don't wait until you're worth $8-9 billion before you decide you want to
well,
file
and
for
then every time he
divorce.
kept saying, well, but I'm going to lose half. Like, well, yeah, well, sure.
Yeah.
And every day that goes by, it's half of a bigger number. So I don't know.
And you're going to keep 100% starting tomorrow.
Okay, is
So
it cheaper to keep her, as they say, or vice versa? Okay, maybe, but what's the
I
price
don't
of
know.
being married to somebody that doesn't love you
Yeah.
or it's treating you poorly? I don't know. So
Well, here's the thing. She could also file for divorce.
Well,
You're
that's
not the only one controlling the divorce filing, like, right?
exactly. So
Yeah.
other interesting note in this, Rahul, this other story, we
Yes.
have both of these
But
stories
wait, there's
linked.
more.
Talk about the
Mhm.
additional thing that's going on in this case.
Yeah, so this is so we've given you the background about what's going on, all the stuff. So then this next New York Post article, also through Yahoo, that was uh, published 2 days ago, as of the day of this podcast, which is August 18th, is when this article was published. Says that wife of hedge fund mogul barred from testifying in record-breaking New Jersey divorce case after hacking his emails. So what happened is, it looks like state family court judge Bruce Buechler determined, according to this article, I'm quoting it, 56-year-old mom of three, Laura Overdeck, engaged in multiple discovery abuses, citing several examples of domestic espionage and evidence destruction. And so what she's basically done, it sounds like, according to this article, is that she's illicitly accessed his private computer to take photos of emails he exchanged with his lawyers, broke into his post office box, and deleted evidence from her phone.
Wow.
So what this really means is that, according to the article, she's not going to be able to testify at her trial, nor is she going to be able to call expert witnesses. And believe me, in a trial like this, where you're trying to establish what the growth of the business is during the marriage,
Yeah, we just
you're
talked
going to need
about it.
experts. Yeah, we just talked about it. You're going to need and if you don't have experts, someone's got to testify. I mean, you can't testify yourself, so who's
Right.
going to say anything? Your lawyers can't testify for you. Your lawyers can argue the legal claims, and
all they can do is
based on the evidence presented,
they can only cross-examine
right?
the other expert.
They can try and show that the expert for the other side got it wrong, but they can't get it to say what the right number is. So, uh, so it looks like, so this article also says he was in court and he looked like he didn't have a care in the world on that last court date. And
What, John Overdeck?
so John Overdeck. So he
If I had $80
was,
billion, by definition, I don't have a care in the world.
I don't have a
Even
care in
if
the
I'm getting
world,
divorced.
and I'm getting divorced, and if I know that my wife is
Oh,
not going to be able to testify,
oh yeah, it doesn't get any better than that. That, by the way, we want to
right?
tell ladies and gentlemen, that is, I've never heard of that happening in an Illinois case.
I know
Now, I
it is
realize I haven't been everywhere.
extremely rare, right, to
That
have
kind I
that
mean, bar,
level of sanctions.
barring a party from testifying is super extreme, and barring their witnesses from testifying is mega extreme in a
Hmm.
divorce case. So we saw that, we
Right,
both saw that. We thought, holy crap, this has got to be bad.
right, exactly. No,
Um,
absolutely. So the judge found in April that she, according to this article, she snapped pics on her cell phone of John's emails discussing legal strategy, and then failed to produce the phone, according to the transcript. I guess it sounds like it was a hearing transcript where the judge's ruling, oral ruling. Despite the court order, she didn't turn over the phone until at least 13 months later, and the images had been deleted, with her claiming the device was running out of memory, according to the judge. So he also said whether she did it maliciously or accidentally is not relevant. There's a cumulative effect here.
sure.
And then the ruling also found that the wife convinced the post office to provide her with an extra key to his private PO box so she could access the mail in that box. And she wouldn't say what she took, or nor would she return it. And the judge opted to dismiss the wife's divorce complaint, calling it the ultimate sanction, severely limiting her options in the Newark courtroom. So it sounds like maybe he dismissed her divorce complaint. Maybe it was a counter petition. Maybe it was seeking, again, guys. Again, we should, like we always talk about, a lot of times the article reports it, but the guy writing the report or the article is not a lawyer, so they might misinterpret certain rulings.
Yeah. It's extreme remedy. It'll be a subject of an appeal if the judgment's entered. Her lawyers will say that it was too much, and the judge shouldn't have barred her from testifying. But it's got to be the very, very extreme if the judges, make that kind of ruling, confident it'll be sustained on appeal. Pretty interesting. This is some tips about what not to do. You can't delete evidence from your phone, folks. Can't delete emails or photos off your phone once you're involved in litigation or text messages. That's called spoliation of evidence. That you get in trouble for that, as she has here. You can't break into somebody's computer where they have an expectation of privacy and copy the materials. By the way, you can get a court order to get a computer copied, and that's the right way to do it. So you talk to your lawyer and say, I want to seize the computer and get it scanned and get a copy of the drive. You can do that. You have to follow rules. There's rules for this game. You can't hack their computer and start copying emails. So uh, that's
As tempting as it might be, I know we probably all had clients ask us, "Hey, should I do X, Y, and Z?" The answer, as they might have a devil sitting on their shoulder telling them, "Hey, you know what? No one's going to find out if I grab this evidence. No one's going to know. We got a red herring, but I can't access it. Just don't do it. There's
right.
ways. Tell us what you think there's out there. People will issue discovery. You got to do it the right way. It's
Yep.
never going to end well for you if you do it illicitly or unlawfully."
Yeah, it's crazy. So let's talk about Liz Cho. I've got to get this up from a share screen real quick. So in case you don't know Liz Cho and
In
Josh
case you're not
Elliott,
up in the Cleveland news anchor scene.
if you're not in Cleveland, if you remember the movie Anchorman, this guy looks like a guy who would be an anchorman. So let's share the screen so you guys can get a good look here. For those of you, this is why you watch the live stream on video, folks, is that you get the benefit of the screen share. And why isn't it sharing? Oh, here we go. Finally, my computer is acting up on me. Hold on, I'm closing some apps so we don't have trouble. Sorry about this, folks. We just have a little technical difficulties, but we'll be with you shortly. All right. Here we go. Okay. So this is Josh Elliott, anchor on local Cleveland TV. So Divorce gets messier as accusations pile up. This is Mr. Elliott, and Liz Cho is there a picture? There's ads. We didn't want to see that. Why aren't they showing? Okay. Sorry, folks. I don't have a picture of Miss Cho. Let's see about page 6. We will link these articles. Here she is. Okay. This is Liz Cho, the lovely couple back in 2016. So here's the scoop. This is, oh, you couldn't see that because I wasn't sharing. My bad. All right, we're going to stop sharing. I'm causing you guys trouble. So the scoop here is interesting. Why are we talking about a Cleveland divorce? Because there's some interesting things going on here. She is WABC news anchor. He is a former TV host, Josh Elliott. She filed a protective order to halt a deposition that his legal team scheduled for July. This happened back in July. Court papers obtained by Page 6 show the deposition was scheduled without consulting Cho or her attorneys about their availability, which is kind of weird. The only way that happens is like you send out a subpoena to schedule a deposition. Her lawyer said they informed Elliott's team of prior conflicts and suggested dates, but received no response when opposing counsel was on vacation. And my guess is this was for a third party deposition, because in a party dep, they just say, no, we're not going to meet you at that time. And you go back and forth trying to coordinate a date. And if they drag their feet too much in scheduling a date, you go to the court and you file what's called a motion to compel to force them to appear for deposition. They get some slack. They'll get to do a few continuances. And eventually a judge would say, hey, you got to show up for your deposition. You can't drag this out forever. But here's what's going on here. The battle intensified since Elliott filed to end the marriage in June 2025 after 10 years. A Connecticut judge recently ordered Cho to provide communications with journalists about the divorce. Apparently, she's communicating with journalists about her divorce. And he's saying, hey, you have to disclose that communication, which you do. You can't keep that stuff confidential. And when you talk to third parties, that's not privileged. That's not protected information. So, and also information about a $500,000 transfer from a joint bank account to her daughter's account in October 2025. Well, isn't that interesting? And when they, all they get was this, crickets. So the bottom, that's, as the kids say, sus.
Okay.
That's a very sus transfer after this divorce gets started. So June 2025 case is filed. October 25, $500,000 goes out of the joint account, goes into one of her kids' accounts. During her hearing on July 24th, she agreed to turn over correspondence, which means emails and texts, folks, too, with anyone with whom she had a romantic or sexual relationship between 2015 and 2025. She previously opposed the request. Now, that is not relevant to the why they're getting divorced. Well, in Illinois, let's talk about Illinois. Doesn't matter why you're getting divorced or that you're cheating or whatever. Now, I don't know. Ohio law might have there might be some fault still going on in Ohio. It might have some impact if there's an affair going on. What you are allowed to discover with romantic partners is, did any money change hands? Also, what did you tell them, if anything, about the divorce? So you get to know the communications and you get to find out, did any money move around? That's all that's relevant with other relationships in our state. And both parties have accused each other of, misdeeds, taken a couple. This is for those, the 1%, let's put it that way. Cho claimed in January Elliott took substantial furniture and the couple's 2 Portuguese water dogs from their home, very, very shishi, and said jewelry only Elliott could access had gone missing. Okay. Elliott disputed those allegations, saying he did not ransack the marital home and only took limited items to create a safe haven from Cho's, quote, escalating and erratic behavior. I'm quoting the story. He accused Cho of monitoring his private phone calls and confronting him for washing grapes for his daughter's lunch. Okay, don't get that one.
Kind of weird.
Excuse me. This is great. Saying she told him the grapes belonged to her and he was not allowed to use them. Oh, okay, totally normal. Apparently, They met while working at ABC, married in 2015. Elliot used to anchor Good Morning America and worked at NBC before serving as daytime anchor for CBSN. He was let go from CBS in 2017. So that's the scoop on them. But again, a little bit of shenanigans going on with evidence and trading accusations. But um, watch out for these financial transfers and understand that you've got to turn over this evidence. That's kind of the message we're trying to send here is don't obstruct people trying to find evidence. Don't delete stuff because you start losing the meta case. This judge in the billionaire case, he's not going to think this wife's credible or that anything her lawyers say is believable. And that's not a place you want to be. So she went from looking like the victim, it's like, oh, he controls all the money. He's the bad guy, the husband and all that, right? That's the way they portray it. And then she starts to look like the bad guy with all these shenanigans. And you don't want to lose that moral high ground in these cases.
No, definitely don't.
You want a fair shake from the judge and not have him thinking that you're the problem. So let's talk about this. Let's talk
this
together,
is kind of an
shall we,
interesting one.
about this Blindside story. What's going on with this, Rahul?
Yeah, so Blindside, an actor, Quentin Aaron, said, and this is, by the way, an E! News article titled, Blindside's Quentin Aaron hasn't spoken to wife since learning she was married to another man after coma. So definitely you got to think about what that title is saying. It's a little hard to comprehend.
We were looking at this before the show, like, what's happening here? What the heck's going on?
Exactly. So could be written a little better, kind of gives your, get a headache thinking about what the title's trying to say. But basically what's going on is Blindside actor was in a coma for 4 days. So he's married to, well, let's say, like, let's step back. He thought he was married to, quote unquote, Margarita de Leon, with whom he had tied the knot in December 2024. And so he had, according to this article, a spinal issue. Let me see what the article says. Give me 1 second here. It said,
it's crazy story.
Yeah, there we go. It says here
some kind of embolism.
Yeah, it was a pulmonary embolism that resulted in some sort of a spinal issue that then made him go into a coma. He went into a coma for 4 days, and then he said that spinal stroke and pulmonary embolism. So he learned that his then wife was still married to the guy she was married to in 1992.
Yep.
And then he said that he absolutely believed she was divorced. And then he said, I wouldn't even spoken with her if I knew she was married. And he's like, I'm not the type of person that messes with married women. And she kept telling me she was divorced for 10 plus years. She, to her credit, also said she wasn't aware that she was still legally married. Her estranged husband, Eric Guzman, also told the news outlet, so it sounds like E! News, that he thought the divorce filing had successfully gone through years before.
Yeah, really weird.
And so it then sounds like he said he was intubated. He remembers seeing her in and out. And he said, thankfully, the marriage was voided. So it was voided because it was a void marriage to begin with.
Can you explain that a little bit?
So marriages could be, so if you have a marriage that is legally unsupported, it can be invalidated. Or if it does not meet if you don't meet the requirements to get married to someone, your marriage could either be void, meaning you can't be married, or voidable,
basically legally.
Yeah. Or it could be voidable, meaning you can go to court and have it voided.
Right.
So void marriages could be like you don't have the ability to get married to someone when you're already married to somebody else. I don't care how many,
you're underage.
Or you're underage, so let me ask you this. So could somebody underage, does that make it voidable, or is that void to begin with?
It's void. It's
right,
because they don't have the capacity to marry.
To consent. So a voidable marriage would be some sort of a technical deficiency, you don't consummate the marriage or something like that.
I'd have to think about right. I'd have to think about that one. But bigamy is void.
It's definitely void. So
the interesting story on that, the flip side of that, I did research on this several years ago because I had a similar question came up, believe it or not. If the divorce goes through on the first marriage, the second one is legal.
Exactly. Yes, that's
It's
exactly
it's
right.
like cured.
Yep, you can cure the deficiency. Exactly. So, uh, but that never went through, and they
Yeah.
avoided this before that could have gone through. Now, so having done this for a long time as you have, and also as you know, I've done it for a little less time than that, but we often hear about people who genuinely think they've been divorced because
Yes.
someone would have filed for divorce, someone would have gone to a few court appearances, but the judge would have probably said to them, "Hey, I need you to submit X, Y, and Z, and then I can sign off on it." And then not having any representation or whatever, they might have dropped the ball somewhere and then just moved on and then said, "Hey, yeah, I was in court 10 years ago. I'm sure I was divorced by now." And it just, that final execution sort of element just never happened. And
Yeah.
so I,
Yeah.
I don't necessarily think that she lied to him because a lie requires you to know the truth. I think she might have
Especially if
genuinely thought she was divorced. Yeah.
especially when the other husband says, "I thought we were divorced too."
Right.
So it sounds like some kind of glitch,
Hmm.
maybe. I mean, I give her the benefit of the doubt,
Right.
but I don't blame the
It's a
guy.
distinction without a difference. Yeah, exactly.
I
For
don't
the
blame
guy.
Aaron for freaking out and saying, "Hey, come on, I'm not doing this." And then
Yep.
he had the world's easiest way to terminate the divorce. If it's
Right.
void, that's a
Hmm.
petition for declaration of invalidity of marriage. And
Yep.
those are rare. You rarely see a void
Hmm.
marriage, almost
Yep.
never.
Right.
So he has one of those rare cases when he when he called the lawyer was like, "Wait a second, what?" And then, you have to go get the proofs. They had to go research, I'm sure, and pull that court file and
Sure.
find out that it was never done and there was no decree entered, and then that was their evidence for their invalidity,
Hmm.
saying,
Yep.
this guy, his marriage is void. And here's the important thing about void marriages that you should know, folks. If you have a void marriage, there's no marital property, there's no right to maintenance.
There's no
So
marriage.
you basically go back, and this can be very challenging if it's been a while. If you've been married a long time, you have joint accounts and stuff like that. Untangling it is a mess because you've kept everything together, maybe, and now you have to go back to square one, and you got to go back to the time when you were married
Right. So
to
it could be a
figure out.
mess.
It could be a huge mess to untangle it. They don't
It's like
mention
you
it in
had a
the header,
roommate. It's like you had a roommate with whom you started opening joint accounts
right?
and bought joint property together. And now you're going to have to figure out, hey, what do we do with all this since we're no longer friends anymore?
With all the problems that go with that,
Yep.
and the divorce court won't help you. So
Yeah.
it's got its own problems. So you say,
Hmm.
"Yay, my marriage is void," and I get out of it. Yeah, now you got to untangle all the crap that's been connected over the years.
Right.
So it's not easy. So
Hmm.
okay, I just thought there was interesting like discussion
Yeah.
there. Um, let's talk about. I'll read this question, and then you and I can discuss it. So
We can
we
discuss it. And I know we're a little short on time here, folks. So we'll
we
be
are
a quick little discussion here and then we'll
right. We want to hit
extrapolate.
we
Yeah.
want to hit you guys with this to give you a little background. So this is from the Illinois Divorce Support Network, our Facebook group. Free to join, anonymous to post. And we have like 1,700 members. And they answer each other's questions. It's about Illinois divorce. If you want to come in and join anyway, you don't care about whether it's Illinois or not, you're welcome. We don't have like some screening test. And you might be able to get your general questions answered. Um, okay. So, not legal advice, by the way. Parenting coordinator. We have this role in Illinois governed by now Illinois Supreme Court Rule 909. Remember, folks, there's a federal Supreme Court, the big guys in Washington, and every state in the United States has a form of Supreme Court, although it has different names. The Supreme Court is what our top court is in Illinois, and they govern the leader management of attorneys, and they govern the rules about how courts handle their business. And one of the rules is 909, and that rule is how parenting coordinators work. And Rahul, can you talk a little bit about what parenting coordinators are and what they aren't?
Yeah. So a parenting coordinator is, almost definitionally, it sounds like, just what their role is to help high conflict parents make day-to-day decisions or reach agreement on day-to-day issues that might come up that the two of them do not have the capacity or ability to resolve amongst themselves in order to sort of keep things fluid and to avoid them coming to court for every little thing.
And
So
when do they typically get involved in a case?
they typically get involved in the case towards the end of the case
Right.
unless someone thinks there's some intermediate reason. Usually, the courts like to have both parents just work these things out themselves. A lot of times, high conflict cases have guardian ad litems who are essentially court investigators who serve as the eyes and ears of the court in order to recommend to the judge after their investigation what the child's or what's in a child's best interests as it relates to parenting time, decision making, and everything else that goes with that. So then, they could also say, look, if one parent says the sky is blue, the other one says it's red. They just cannot agree. And while that could help make decisions, a parenting coordinator can't make a decision on behalf of a parent, by the way, or they
Right.
cannot tell you if one parent says, I want to give this child braces, and the other parent says, no, I don't want to do braces. The parenting coordinator can't come in and say, you're doing braces. They can't do that, but they could kind of help talk to both parents to see if they can bridge the gap. But what they can do is things like, hey, so and so wants to take a vacation this week, but I don't want to switch. The parenting coordinator can say, yes, you're switching.
Right.
Yeah, so they can make those little small time items or issues get resolved without looping in two attorneys, potentially going back to court, avoiding attorneys' fees. And they're
Right.
right there. They're on a retainer, and you'll use them as you need to. You don't have to use them if you don't need. They'll just kind of hang out until you bring them in for discrete issues. They're not involved in your day-to-day things like a GAL would be. They're not going to be interviewing the children and things of that nature. They're not going to come to
Yeah.
court and say, so and so was bad.
They don't
So
decide changes in the parenting agreement.
correct. They
They're
don't
there
do
to
that.
they're there to interpret the vague parts and help reach agreement on small time things.
Right.
So
Exactly.
can you so here's the question we got from the Facebook group. Has anybody had experience with a parenting coordinator? I'm thinking about getting one, but I don't know if it's going to be the same thing like my past experience with our GAL, which was a nightmare. I'm concerned he may just encourage conflict sometimes so they can make more money. Now, I'm not sure if this person means their soon to be ex is the one encouraging conflict or the parenting coordinator.
Right.
I can tell you the parenting coordinators are plenty busy without encouraging any
Yeah.
conflict.
Right.
Now, I don't know if they mean personally or that by just having them, the existence of the coordinator will cause their ex to hype up and cause trouble just to cost them money, which is possible.
It's also
It says,
possible.
does anybody have a recommendation of a person they use that's been helpful and experience they could share before I make a decision? So they said the parent is extremely high in conflict, doesn't follow court orders, changes interpretation of order to benefit themselves. Well, that sounds like something where a coordinator could help when
Exactly.
they're changing the interpretation to benefit themselves.
Yep.
That would be useful. Rahul, you have an example in a real case about a coordinator being helpful. Can you talk
Ye-
about that?
Yeah, and I don't want to use actual names, for the fear
We
of
won't.
getting anyone doxxed. So, so we had this case, a very, very high conflict case, and they again couldn't agree on interpretation, couldn't agree on structure, couldn't agree on just basic things like phone calls or exchanges, things of that nature. And so we looped in a parenting coordinator, and they proved to be extremely helpful because they kept both parties in line, they kept them grounded on what their obligations were, and they didn't take crap from either person in order to kind of to keep the parenting going well, and it worked great. I thought that
Yeah.
person was a wonderful parenting coordinator for both sides. And so I think the children really benefited from that. Now, the experience with the GAL, I can't speak to. I also don't know that GALs necessarily stir up conflict or that maybe your ex brings up issues to the GAL that would then have caused them to necessarily investigate those things.
Yeah.
That being said, go ahead.
Yeah, that's the only thing I would raise is
Mm-hmm.
depending on your situation, a parenting coordinator might be just another person that the other parent runs to just create trouble. Now they bomb them with email messages and calls all the time to now there's yet another platform for them to cause trouble. Now the good coordinators know how to deal with that and they don't allow that to get out of control. So in general, we think they're a helpful thing. But it's a very individual situation. And
Right.
so your mileage may vary. But in those high conflict cases where parents can't get along, or you have a parent that's always trying to wheel and deal on the order, like lawyer the order around. Like what does 5 p.m. mean? It's they're bringing
Well, I
the
was
kid
10
10.
minutes late. What's the big deal?
Yeah, and it's like those kinds of small things that add up or become aggravating. The coordinator can be really useful there, where the issue isn't big enough to take to the court, but it's not small enough to ignore. That's where the
Right.
coordinator comes in handy.
Exactly,
So,
exactly. And so overall, the coordinator would be a net positive without knowing anything else about what's going on, I think.
yeah.
Although that's not
So,
legal advice.
exactly. So, thank you everybody for watching the show today. We appreciate it. If you have questions, please let us know. If you have comments, let us know where you're listening. The comments are helpful. Like, share, and subscribe to the show, please. If you like it, follow us on Instagram. We're at STG Divorce Law on most social platforms. I'm at Rayford Palmer. And how can people find you, Rahul?
You can find me at Chicago Divorce on Instagram and on LinkedIn
Yeah,
and our website.
we're real easy to find. And STG Divorce Law, very easy to Google. You can look either of us up too and search out for the I Just Want This Done Divorce podcast. Uh, it's I Just Want This Done pod.com for the pod website to watch prior episodes and get other information about the show. If you're interested in being a guest, you can reach out to us directly. If you go to the show website, there's information about how to contact us. Thanks very much. We look forward to talking to you again next time. I'm Rayford Palmer. That's Rahul Iyer, and we are out of here.
Thanks.
All right.